I'm
Stan,
testifying.
yeah, you are. You're saying what somebody else told you. You can't do
I'm
that.
testifying.
You can't testify to what someone else told you
Uh,
for the
uh,
30th time.
Okay, so there's no voluntary admission into Peachford. Okay. There's also a period of time that people have to be held when they are involuntarily committed into a mental institution. And it was on this exact timeline that Melody was kept in there. So everything adds up to the fact that this was involuntary. They won't provide any information. I've asked for it. Her attorney has told me that she would provide information. She has not done that. I made the decision at like 8 or 9 in the morning on Saturday, April 28th, to drive to Georgia to maintain continuity of education, life, stability, everything else for my children because their mother was institutionalized. On the way up there, I had
Okay, Mr.
conversations.
Parkhurst, I think that it has been established that she entered into Peachford. What you need to focus on is how there is an adverse impact on the children requiring me to
Well,
make
there's
a
an
material
adverse
change
impact
of
on the
custody.
children because they were adrift for a period of days with no legal guardian, zero. And frankly, I didn't want to call DFACS because I don't want to get DFACS involved in my children's lives. Instead, I drove from Florida to Georgia to parent them. The kids knew I was coming. The kids knew I was there. The kids knew I was meeting with school administration. The kids knew that I was there to help them with their homework, any thing that they needed to do to live, to bathe, to brush their teeth, everything. Their mother could not provide that at the time. Their mother was also restricting my access as their legal guardian at the time from a mental institution when she did not have authority to make those decisions. The school administration, which I spoke to both on Saturday, part of Sunday, and on Monday, said that they have had run-ins with Melody about paranoia surrounding COVID, which makes
Objection,
sense
Your Honor,
based
hearsay.
on.
Stain.
And then the other caretakers are all very, very concerned about a
Objection,
devolving
hearsay.
Stain.
mental state.
Sir, you can't offer the testimony you're attempting to offer by
On
just saying.
Sunday, April 30th, I submitted an emergency petition for modification. Now, it seems really funny to me that anytime Melody, Miss Parkhurst, submits any emergency modification,
We're not here to talk about what she submitted in the past. We're here to talk about whether
okay,
you have
I'm
grounds to
talking about a
for your
double
petition.
standard here. Anytime I issue something, it
Mr.
takes a month.
Parkhurst,
Anytime she does it, it's
out of
24
order.
hours.
All right, I'm going to conclude that that's all you get
Okay,
about.
then I talked to Kenzie Lee.
You can't
who
talk
is-
about what you talked to someone else about who's not here to testify.
Okay, Kenzie Lee was asked by Melody from a mental institution when she had no decision-making authority to take over care of the children. Well, guess what? Kenzie Lee knew I was in town. Kenzie Lee knew I was right there.
Objection, Your Honor, hearsay, calls for speculation.
It's not hearsay. I was in a hotel room.
You just said Kenzie what she knew. She's not here to say that that's
I
true.
came to town. The kids knew it. The kids wanted to be with me. That was not allowed by somebody making decisions, again, from a mental institution. And that's pretty much it. I mean, your court decided this was not an emergency. I still don't have appropriate data as to exactly what happened because the plaintiff or the defendant nor
Mr.
her
Cameron, I
attorney
will note for you that the Civil Practice Act allows for a process to obtain that which you contend you've been trying to offer as evidence. Well, you did not undertake that process, and therefore you neither have witnesses here nor evidence here other than your own testimony.
I came up there. There was no guardian for the children. I stepped in. I was forbidden to do that as their father. No matter what I tried with any of her contacts, Melody's contacts, who she had instructed from a mental institution, they did not allow me access to the
Calls
children.
for speculation.
It does not call for speculation. It's
Mr.
fact.
Parkhurst, finish your statement. You cannot talk about what other people said, did, or thought who aren't here.
Then I submit every single text message that I have sent to the court. It's items P7, P6, P5, P4, P3, P2, and then P1. I would like the court to listen to the voicemail that I had previously submitted from Melody's friend Lauren on April 28th in the evening that literally says that she's concerned about her mental health.
Your Honor, I would object to all exhibits with the exception of P3 on the grounds of hearsay.
They're not hearsay. They're
What is
text
P3?
messages.
P3 is a series of text messages from Kenzie Lee. She will be able to testify today.
Okay, Mr. Parkhurst, she hadn't testified yet.
Is
so
Kenzie Lee here today? Is she in this room right now?
I don't know, but at this point, she hadn't testified, so you can't.
Okay, well, I'd like to call her if she's here, so bring her in.
No, you can't do that either if you didn't subpoena her. If
I
that's
asked
their
her
witness,
and she said no. So
if they subpoena her, you will have the opportunity to cross-examine her. If you didn't subpoena her, you can't call her.
It's a joke.
That's what I'm talking about. You have to know the process.
It's an absolute joke. So you're not going to allow me to send you into record.
I am not going to allow you not to follow the rules of evidence and the Civil Practice Act of the state of Georgia. You have more than tried to defy, and I'm not going to allow it. It's chaotic. I'm not doing it. No.
Why is
I follow the law? That's why I choose to follow the law, Mr. Parkhurst. That's
why is item P1 a voicemail that Lauren McHenry, Nita, whatever her last name is.
I know you're not a lawyer, but I know you've heard me say now for the 32nd time that you cannot testify to or submit evidence between someone who is not here and has not testified. That's called hearsay. Can't do it.
How do
they would have to be here?
Evidence from a person who sent me. I'm here.
You're here. You can testify.
So fine. I submit as testimony.
No, that's not
exhibit P1.
That's not how that works, because you are not the only person on that exhibit.
So wait, so Kenzie Lee, who I asked to testify, who said no, is now allowed to be brought in by Melody.
Yeah, because see what happens is if you don't avail yourself of a process to properly subpoena, why am I bothering with this? Okay. You have any other questions? I mean, any other statements you want to make, Mr. Parker?
This is a blatant.
You are the blatant person who is disregarding all rules of procedure and process repeatedly. Your behavior is abusive.
I rest.
It is atrocious, and it is quite frankly taking me to the end of my fuse for a emergency hearing that you asked for that was delayed, that you could have used the time to avail yourself of the Civil Practice Act and civil procedure, and you chose not to do so. And now you want to hold the court out as though the court has somehow withheld some opportunity from you. You did this to yourself. So you will have to live with that for now. You rest. Ms. Safakos, do you have a presentation, ma'am, on behalf of Ms. Parkhurst?
Yes, Your Honor. At this time,
And let me remind you, I've got somebody else coming back at 3:30 because y'all are well outside of your time announcement. I'll let Mr. Parkhurst go first because it was his motion. Please be mindful of the time.
Yes, Your Honor. I would like to call Ms. Kenzie Lee. Your Honor, I believe she is in the waiting room.
Ms. Lee? Give me 1 second while she comes into the Zoom. Be right.
Thank you. Thank you, Your Honor. May I proceed, Judge?
Yes, ma'am.
All right, Ms. Lee, if you could please unmute yourself, raise your right hand. Do you swear or affirm that the testimony you're going to give the court today is the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Okay, place your hand down and state your name for the record.
Shannon Kenzie Lee.
Okay, and Ms. Lee, how do you know Ms. Parkhurst?
I have known Ms. Parkhurst for, goodness, probably 11, 12 years now, both as work colleagues, but also as personal friends.
All right, and do you, have you had an opportunity to interact with her and her children?
Oh, I have. I mean, I've seen them in lots of different situations, school, birthday parties, like Easter parties. They've been over to my house. I've been over to their house. I've seen them when they've been at work. So lots of different types of situations.
Okay. On April 28th of this year, did you take the children into your care?
I had them on the 29th. That was Saturday.
Okay.
And that's when the kids came to stay with me the late afternoon on the Saturday, the 29th.
Okay. And who requested that the children stay with you?
Melody did.
That's Ms. Parkhurst?
Yes, Ms. Parkhurst.
Okay. All right. And did you subsequently go to LJ to stay with the children?
Yes, I did. They stayed with me Saturday night at my home in Lilburn. And then Sunday afternoon after church, I drove up with the kids to LJ. Okay.
All right. And did you take the children to school?
Yes. Monday through Friday, dropped them off every morning, picked them up in the evening.
Okay. And were they there on time?
Yep. Every day.
Okay. Did you take the children to any therapy appointments during that time period?
They did not have any in that time period. I think Thursday afternoon, we thought they had one and then ended up not having one.
Okay. All right. And while the children were in your care, did you ensure that they spoke with Mr. Parkhurst?
Yep, I sure did. Sometimes we weren't available, but I always tried to make sure we gave him a call back as soon as we can.
Okay. How often did the children speak with Mr. Parkhurst?
I think he spoke to them at least once a day on most days, if not more.
Okay. All right. Now, did you retrieve Miss Parkhurst from Peachford on the day that she was discharged?
Yes, I did.
Okay. And did you participate in her outpatient conference call?
Yes, I did.
All right. And did you stay with Miss Parkhurst in LJ after she was discharged?
Yes, I did.
Okay. For how long?
I stayed with her until Saturday afternoon.
Okay. All right. And so did you had an opportunity to observe her with the children?
I did.
Okay. And what are some of the things that you saw her doing with the children?
All of the things that parents have to do: get them up, feed them breakfast, get the snacks, get more snacks, diffuse, sibling, rivalry, as we all have to do.
All right. And have you been in contact with Ms. Parkhurst since you left on May 7th?
I have.
Okay. And how does she appear now that she has been discharged?
Yeah, I mean, it's been great seeing her and talking to her on the phone. I mean, she's more lively. I can tell she's got more energy and just seems more well-rested overall.
Okay. All right. No further questions, Your Honor.
Mr. Parkhurst, cross-examination.
Hey, Kenzie.
Hi, Cameron.
Good to see you. Not too many questions here. I guess a little bit of a surprise that I guess you said it on this outpatient conference call. Can you provide more details therein?
Yeah, I mean, I just actually sat in and listened in. They requested that. We just talked a little bit about some of the things that Melody would need to do once she got home.
Okay. Did they talk about a diagnosis therapy, treatment, ongoing, anything informational that you can share?
I honestly don't remember if they discussed diagnosis or treatment. Most of what we talked about was just, what can she do to kind of help herself when she needs to get a break. We talked about getting outside, going for a walk, talking with friends. And another part, if I'm remembering correctly, that we talked about was just the need to try and get back to Lilburn so she could have, a better support system around her.
Okay. Appreciate that. So it was shared, I guess, that on the 29th, Melody reached out to you and requested that you pick up and drop off the kids and do whatever else. And I'm fully aware of everything you did. I'm appreciative of that. But when did this request come in?
I think that it happened on Saturday.
From Peachford?
No, not from Peachford. I didn't talk to anybody at Peachford, except to request to talk to Melody.
Okay, but Saturday would have been the
29th?
28th, I believe.
Saturday, April 29th.
Okay, but she was in Peachford from the 28th, 29th, 30th, and thereon. So if you got instructions from her to do anything, it came on the 29th?
I believe that, I don't know what happened on the 28th. Morgan maybe had them on that then.
Mm-hmm.
Yeah.
Okay. So she didn't talk to you before she went in to the emergency room or to Peachford a few days prior? What happened?
I didn't talk to her a few days prior. No, I don't remember, and I didn't take notes whether I spoke to her on the 28th.
Okay. And I guess, can you give your recollection of during the time when all this was happening, obviously over a period of time, I reached out to you, we had conversations, we had text messages going back and forth, I was driving up there, etc. Can you just explain to the court our interaction throughout this entire time, my interaction with the kids as well?
Sure, yes. So I remember on Sunday, I think that's when you were driving up, and I had one conversation with you over the phone. I remember I had it on speakerphone, and my husband Derek was on the call, and you just kept saying over and over again that I'm the dad and I'm the responsible person, and that you were going to be up there. And after that call, my husband suggested that I probably not take any more phone calls from you. And so then after that, we just texted back and forth. It was pretty transactional, trying to just make sure that you knew where the kids were so that you had that information, and just letting you know how their day went, that they made it to school. So just pretty transactional conversations via text after that.
Okay, but I was provided opportunities, obviously, to talk to the children multiple times a day, right?
Yeah, yes. And
yeah.
I had no concerns over the conversations that I heard when you had the opportunity to connect with the kids. Most of the time, the conversations were on speakerphone.
Okay. And I guess, were you aware on Monday when you dropped the children off? I think I'd shared with you that I was going to meet with the school admins and everything else, but are you aware that they didn't know who you were when
objection calls for speculation?
I'm asking a question.
Let me hear the question. Was she aware?
Are you aware that they did not know who you were when you dropped the children off?
That who did not know?
The school administration, North Georgia Christian Academy.
No, I was not aware.
And are you aware that they did not know who was picking the children up that evening?
Objection calls for speculation.
Did you
He asked if she
communicate
was
with the
aware.
school to?
Hold on a second. He asked if she was aware, so she can answer if she's aware or not.
No, I was not aware, but I did tell them that I would be there to pick them up when I dropped them off.
Okay, so that's similar to what I recall as well. So, I mean, I guess there's no further questions. There's not a whole lot of information here.
Okay. Anything further, Ms. Safrakos?
No, Your Honor. May this witness be released, Judge?
Yes, ma'am. All right. You have any other witnesses?
Just the Miss Parkhurst, Your Honor, just briefly, so she
Ms.
can.
Parkhurst, briefly.
Okay, thank you. All right, Miss Parkhurst, you're still under testimony. I just wanted to, I'm sorry, you're still under oath. Your Honor, may I have the ability to share my screen?
Yes. All right, I see that the Bernice parties are back. I am still in this hearing. You all can hold. I suspect we'll probably be done by 4 o'clock. But I don't know that to be a fact. So we're trying to come up with an alternative.
All right. Ms. Parkhurst, you mentioned during your cross-examination by Mr. Parkhurst that your email had been hacked.
Yes.
Okay. Did you take screenshots of the notifications that you received?
Yes, I did.
Okay. And what I just placed on your screen is R1. Are these true and accurate copies of the notifications that you received on April 21st?
Yes, they are.
All right. At this time, I tender R1 into evidence.
Any objection to R1, Mr. Parkhurst?
Everyone's computer gets hacked, so no.
Submitted.
All right. How long were you in Peachford, Ms. Parkhurst?
4 days.
Okay. All right. And
Judge Jackson, we already know a lot of this information, so why are we rehashing?
She can get herself oriented to what she would like to ask. Go ahead, Ms. Safrakos, quickly.
thank you, Your Honor. All right. And so, well, Judge, has R2 is already admitted, correct?
Through Mr. Parkhurst.
Yes. Okay. All right. Now, according to the R2, the discharge paper or the letter from Peachford, you're to be under the care of a therapist. Are you currently under the care of a therapist?
Yes, I have my regular therapist that I was seeing all along, and I'm started a new therapy called EMDR to help me process trauma.
Okay. How often do you see your regular therapist?
Once a week.
And how often do you see the trauma therapist?
Right now, once a week, but as we start EMDR, if it's too intense, we'll do it every other week.
Okay. And were you prescribed any medication from Peachford?
Yes, I was prescribed, sorry. Yes.
Are those?
What's that?
What are the medications?
Oh, sorry, I was prescribed Lexapro, which is for anxiety and depression. And then I was prescribed Klonopin if I was having an acute panic attack. And then I was prescribed Trazodone as because I asked for something that would help me sleep that was non-addictive and that I could wake easily from if needed. And so that's what they prescribed.
Objection, Your Honor. She testified earlier that she does not have medical records that she can share with any of this information. Now she's listing drugs that she was prescribed. So that's
she can testify to that. There's not a legal basis for not allowing that testimony. That's overruled. Keep going.
All right. And are you compliant with the medication requirements?
Yes, I am.
All right. And since you were discharged, have you resumed your duties as the primary caregiver of the children?
Yes, I have completely.
Okay. And who resides in the home with you now?
No one. It's just me and the kids.
Okay. All right. Now you're aware that a new order was entered on April 24th, allowing Mr. Parkhurst to have supervised visitation. Has he reached out to visit with the children at all?
No, he has not.
Okay. Now you also stated during your cross-examination that you were concerned about Mr. Parkhurst's drinking again. Did you receive, since the last time that we
Objection, Your Honor. This hearing is not about alcohol or drinking. This is about her institutionalization.
I need to hear the question before I can rule on that objection.
All right. You stated that you had some serious concerns about the children being in Mr. Parkhurst's care. Why, or did you receive a SoberLink, a notice?
Objection, Your Honor. This hearing is in no way, shape, or form talking about the subject matter. It's talking about her institutionalization.
It's not just talking about her institutionalization. It's about your emergency petition to change custody based on an adverse impact to the children.
None of this was part of the documentation at all.
Well, I saw something and you brought it up too, and she has said and testified repeatedly about a positive blow during.
That was not brought up in my
it certainly was
overruled or anything else.
Overruled, Ms. Safakos Limited.
Yes, Your Honor. All right. Did you receive a notification from SoberLink that Mr. Parkhurst blew positive on April 27?
Yes, I did, and it was very stressful to receive.
All right. And did he miss the scheduled retest as well?
Yes, he did.
Okay. And I just placed on the screen what's been marked as R3. Is this a true and accurate copy of the notification?
Your Honor, I object to this.
She hasn't moved to admit anything yet, so that's overruled at this time. Right. Go ahead.
Is this a true and accurate copy of the notice that you received of Mr. Parkhurst's non-compliant test?
Yes, it is.
All right.
Your Honor, I have no idea where this came from, what website it's from, anything.
Nobody has moved to admit anything yet, Mr. Parkhurst. She's just testifying right now.
All right. And Ms. Parkhurst, did you receive this directly from SoberLink?
Yes, I did.
Okay. And is that the notification email address, the no reply at soberlink.net? Is that the email that you've received from SoberLink?
Yes, it is.
That's okay. And have you received these notifications in the past?
Yes, every day.
Right. And they come from SoberLink?
Yes, they do.
Okay. And has this notification been altered in any way?
No, it has not.
Objection, Your Honor. That she has no way to know this is a photocopy of some random email or text. I'm sorry, but there's no way she can testify to the fact that this has not been altered. It's granular and everything else.
Okay. As to the Ms. Safakos, what's your response?
Your Honor, she testified that she received this email from soberlink.net, that she's received these emails in the past, that this is a true and accurate copy of that email, and that has not been altered in any way. It's not granular, Your Honor. It's visible, and it's directly from her email.
Mr. Parkhurst, that goes to weight, not the admissibility at this point once she's laid.
Your Honor, this is also weight of this case. This has nothing to do with her institutionalization and why we are having an emergency hearing.
Well, it does, because one of the things you elicited from her on her direct testimony when you called her as a witness was part of the reason, and this is in her answer as well that I read, that part of the reason she felt she needed to check herself in was this was one of the pieces of her stress and anxiety.
Judge Jackson, that's not what I listed anywhere in my petition.
Said that is what she tested herself in, was this was one of the pieces of her stress and anxiety.
Judge Jackson, that's not what I listed anywhere in my petition.
Said that is what she testified to, and you elicited that testimony when you asked her why she went voluntarily, which you didn't believe was voluntary. And she told you this was one of the reasons.
Still don't know if it's voluntary. She won't provide that information.
So that is admitted over objection. Next question.
All right. Are the children, during the 4-day time span that you were away, did the children miss any medical appointments?
No, they did not.
Okay. Are they currently still under the care of their therapist?
Yes, they are.
Okay. And are they involved in extracurricular activities?
Yes, they are. Carter just got back from a 4-day scout camp.
All right. And did they miss any school at all?
No, they did not.
How were their grades?
Carter has all A's and 1B, and Madison has straight A's, and they both received awards at the end of year awards.
All right. Now, according to the safety plan that was entered in R2, you stated
Objection.
that you
What is the objection? The question's not out yet.
You just said safety plan. There's no safety plan.
Objection to the characterization response.
Your Honor, it is labeled clearly. It says Peachford Hospital Crisis Safety Plan. R2.
So with that, I guess rephrase your question with how it is labeled.
Yes, Your Honor. Within R2, Ms. Parkhurst, on the Peachford Hospital Crisis Safety Plan, did you indicate that you would speak with management about reassignment with your prior work duty?
Yes, I did.
Okay, and have you since done that?
Yes, I did.
All right, and have you also taken steps to move back to the Lilburn area?
Yes, I have. I continue to take those steps, and I was granted a less stressful position at work.
Okay, and when is it anticipated that you will be moving back to Lilburn?
I'm very hopeful to be back in July.
Okay. All right. And so for the last 30 days since you, or 30 plus days that you have been home, who has been the primary caregiver of the children?
I have been.
All right. And how are the children?
The children are doing great. And they, like I said, Carter just got back from a 4-day scout camp that he really enjoyed and didn't, flex his independence. Madison's doing well. She's prepping for her scout camp. We're doing, lining up our summer activities.
Okay. All right. And since you've been back, do the children have contact with Mr. Parkhurst?
Yes, they do.
Okay. And have you overheard any of those conversations with Mr. Parkhurst?
Yes, I have.
All right. And is there anyone that gave you concern?
There's just been one since I've been home, and I believe it was Mother's Day evening, but Mr. Parkhurst called and had clearly been drinking quite a bit, and it was repeating himself and asking the same questions of the children, and Madison immediately recognized that Mr. Parkhurst was
not— Don't tell me anything about Madison.
Okay, sorry.
Objection, Your Honor. This is going in a direction that's not part of this case. They're trying to throw spaghetti up against the wall to—
Mr. Parkhurst, she just gave Ms. Parkhurst some direction about her testimony. Go ahead, please.
Thank you. Are you requesting that Mr. Parkhurst's petition be denied?
Yes, I am.
No further questions, Your Honor.
Cross-examination limited to what was asked on direct, Mr. Parkhurst.
Ms. Parkhurst, how do you anticipate you're going to move back to Lilburn in July when you own a house in LJ?
Mr. Parkhurst, my current plan is to get pods, U-Haul pods, and to empty our house so that it can be well staged to sell and to rent back in Lilburn, and that way my house would more easily sell without us in it having to show it.
And you've been trying to do this for how long now?
Well, I was initially seeking a rental back when the rental market was bad, then started looking to purchase. And at this point, I think I was very close to selling the house, but I think selling the house with us not in it will be the best bet. It's very hard with children.
You're okay moving back to Lilburn now, even though COVID still exists and you moved away because of the whole pandemic?
We're in a different place now with the pandemic. I'm quadruple vaccinated.
Okay. And you showed something with a SoberLink reading of 0.52. Or 0.052. What's the legal limit in the state of, or in the United States of America on sobriety?
I have no idea.
0.08.
Objection, Your Honor, is testifying.
Have you ever seen a reading on that SoberLink device that's ever been above 0.08 in your knowledge?
I don't recall the actual numbers, but know that you are at a zero, like court order.
I asked a question. Have you ever seen a reading over
I don't remember
0.08?
I don't remember each of the numbers from all of the positive lows.
And on April 27th, 2023, was I with any children?
No, you were not.
Thank you. Now, you talked about the fact that I have not tried to come up to have visitation with the children. Do you know that to be factually correct? Or is that an opinion?
I know that you've not requested any supervised visits with the children since the order.
Are you aware that I have reached out to the child's therapist to get recommendations on family therapists that will coordinate with the child therapist? Are you aware of that?
I saw that I was copied on an email to the therapist. That is all I saw.
And are you aware that I've contacted supervising agencies?
No, I have no way of knowing that.
Are you aware that I've taken tremendous steps to attempt to get up there to have an adequate relationship with my children, including coming up there when you were institutionalized? Question.
Mr. Parkhurst, when you were coming up to see the children, you knew that you had no access to do that. That was court ordered. That was not my decision.
Ms. Parkhurst, did you have decision-making authority from Peachford?
Okay, we're not going to ask the same questions a third time.
Ms. Parkhurst,
next question.
I was unaware that you were on Lexapro or Klonopin. You did not share any of that information with me. You told me, and your attorney told me, that you would provide information in a written form about...
Are you asking her a question?
I'm asking her a question right now. I am not aware of the medication, the dosages, how many times you have to take it. I'm unaware of any doctor's orders regarding this. Are you able to provide me written copies of the diagnosis, the doctor's orders, prescriptions, etc., regarding your medical care, both before, leading up to, in, and now out of Peachford?
I think you're asking for a lot of information that I don't think is relevant to whether or not the children are safe and cared for.
Ms. Parkhurst,
I'm happy to provide another written summary that includes my diagnoses, and I'm happy to provide more documentation on my medications. I just don't think that.
But Ms. Parkhurst, you realize you have been asked that repeatedly and you have not provided any of that information, and that's why I am in the dark.
Mr. Parkhurst, I don't believe you're in the dark. I believe I have tried to provide as much as I could to let you know what was happening with your children and ensured that you had adequate access to knowing that they were safe and cared for. And I know you yourself approve of Kenzie as a caregiver for our children.
Ms. Parkhurst, I have one final question, and answer this as directly and realistically as you possibly can. The coin were flipped, and I was in a mental institution, and my children were adrift out there in society. Would you or would you not think that I would contact you to give you all of the appropriate information and to set up a plan with you as their parent?
Mr. Parkhurst, a lot of what you said, I just totally disagree with. Our children were never adrift.
There's no disagreement. I'm asking you a question to answer directly.
Secondly, Mr. Parkhurst, I would...
Hold on a second. She doesn't have to agree with how you asked the question. That's what she's telling you. You said if the tables were turned, she doesn't believe that the way you turn the tables is an accurate description. So you have to ask the question the way you would like to have it answered.
And do you believe me when I had the one conversation with you at Peachford, and I told you it would never be in my intentions ever to strip you away from your children? Do you believe that?
No, Mr. Parkhurst, I don't. That we are literally...
No further questions, Your Honor. I'm done with this.
You can finish your statement, ma'am.
We are literally here for you to attempt to do that. You put in a petition to do that based on me seeking mental health support.
Let her finish her statement, sir. You asked the question, she can answer and explain.
During an extremely stressful stage of my life, and I would applaud you if you would seek care similarly for alcoholism. So I feel as if
Ms. Parkhurst, you're not allowed to respond back with what you would like me to do.
Mr. Parkhurst, you asked a question. You can't cut her off. Ms. Parkhurst, answer it, and please quickly.
I just feel you were disingenuous and that your actions have not shown that you were supportive of me or our children.
Thank you. All right, anything further?
Ms. Parkhurst, do you believe that a level of paranoia has affected your daily life over the past decade?
No, Mr. Parkhurst, I do not believe that.
Okay, no further questions.
All right, anything further, Ms. Safrakos? Any other witnesses?
No other witnesses, Your Honor.
Mr. Parkhurst, any other witnesses?
No, Your Honor.
Argument? Ms. Safrakos?
Thank you, Your Honor. Your Honor, we are requesting that the underlying petition be denied. There is no emergency that exists. Mr. Parkhurst failed to reach his burden of proving that there has been any harm to the minor children. The testimony today shows that mother made the voluntary decision to get mental health. Now, I understand that there is
objection.
Mincing of words.
This is closing argument. What is your objection?
You can't say voluntary when there's no proof.
Sir, the proof is her testimony. You may take issue with it and you can characterize it otherwise when you make your closing argument. Overruled. Keep going, Ms. Safrakos.
Thank you, Your Honor. Your Honor, even regardless of whether or not Ms. Parkhurst was voluntarily or involuntarily taken to Peachford, the fact is that the children were well cared for during the 4-day period that she was away from the children. She had the wherewithal to go ahead and make plans for the children, despite the fact that father could not do so. There was a court order that was in place that the parties were operating under during this time period that prohibited Mr. Parkhurst from interacting with the children until further notice from the court. So Mr. Parkhurst was attempting to inject himself into the children's lives in a role that had not been approved by any part of the court. It is extremely disingenuous for Mr. Parkhurst to attempt to assassinate Ms. Parkhurst's character because of the fact that she sought to get mental health support so that she could be the best mother. She was doing what was in the best interest of the children, whereas Mr. Parkhurst continues to deny and deflect his issues with alcoholism. Instead of choosing to get help for himself, as Ms. Parkhurst has done, he chooses to instead shoot daggers at her. Despite that, Your Honor, Mr. Parkhurst has failed to prove that there has been any type of substantial change of circumstances. The children, you heard testimony from the witness, Ms. Kenzie Lee, that the children were well cared for during that 4-day period. They went to school on time each and every day. Their grades are outstanding. They are still involved in extracurricular activities. They are still under the care of their mental health providers. Mother has resumed her primary caregiver, her duties as their primary caregiver. And yet father, despite the fact that it has been more than a month since the court issued its order granting him supervised visits with the children, and it has been more than a month since mother has been discharged, father has not taken affirmative steps to contact Ms. Parkhurst to arrange any type of supervised visitation with the children. If he were genuinely concerned, he would want to interact with his children that he alleges are neglected. He is instead using the fact that Ms. Parkhurst took 4 days to get the mental health support that she wanted as a means to attempt to get a second bite of the apple as it relates to the court's order that was issued on April the 30th. Your Honor, Mr. Parkhurst's behavior today, as well as what was put into evidence as R3 showing his sober link test, it continues to show that he is not dedicated to doing what is in the best interest of the children. Ms. Parkhurst testified that she has been under the care of a therapist. She's under the care of a psychiatrist. She has taken her medications as prescribed. And in addition, she's done other things to help give her the support that is needed because she is the caregiver of the children 100% of the time. Mr. Parkhurst has refused to do what is necessary so that he can try to become a more active parent. She has testified that she is moving to the Lilburn area. She also testified that she immediately changed her work assignment to a less stressful assignment. Therefore, under OCGA 19-9-3, she continues to be the primary caregiver of the children, and that is in their best interest. Your Honor, this case is it must be distinguished and juxtaposed to that of Long versus True. That's at 349 Georgia App 875, and that's a 2019 case. It is true that the court can consider changes in a party's mental health to change custody. However, in the case of Long versus True, the mother was completely unlike Ms. Parkhurst. The mother in that case refused to comply with any of the obligations or directives that were given out by her medical providers. And as such, her failure to comply with the medical directives had an adverse effect on the children. The children were missing school. The children were not properly fed. There were also inner disruptions in the children's interaction with the father. Here in the present case, we don't have that. Ms. Parkhurst ensured that the children's basic necessities were met during that time period. And what the court should focus on is the fact that Ms. Parkhurst, despite the fact that Mr. Parkhurst continues to demean her and disrespect her, that she ensured that he had contact, unfettered contact to the children every step of the way. For those reasons, Your Honor, we are requesting that the petition be denied. Thank you.
Thank you. Mr. Parkhurst, closing argument.
Your Honor, I believe you're a mother, and I want you to step into my shoes as a dad, okay? I was given a variety of information about my children who I love dearly. Information coming from a variety of sources. They were coming from caretakers. They were coming from Peachford Behavioral Center. They were coming from everywhere except for from their mother. Their mother was taking evasive action, omitting information flow to me, not allowing me to know what was going on in this exact instance. And so I only had a couple of options. Sit down here and do nothing, or get in my car and come and maintain continuity of education, life, everything else for my children. I was very, very clear on trying to talk to Melody, Miss Parkhurst. She wouldn't correspond. I was very, very overt in talking to the caretakers, Hannah Fleming, Morgan Fleming. I was very clear in talking to Kenzie Lee, who we talked to in this trial. I was very clear in talking to her other friend, Erica. I was very clear in talking to her mother and her stepdad, Melody's mother and her stepdad, who were extremely concerned about her behavior, her ability to parent, her ability to basically do anything in that period of time. But at the same time, all we all wanted, including me, was for her to do what was best to get the help that she needed to get to a place that was sound. Along the way, we wanted to have continuity in the kids' lives. And it was very important because they had 3 weeks left of school. I had made a commitment that I was going to stay in Georgia for 3 straight weeks to allow them to finish up school and to start their summer the way it should be done. That's what I went to the school to talk to with the administration. There is a serious question here as to whether she was voluntarily, Ms. Parkhurst was voluntarily or involuntarily put into Peachford. And by omitting and being evasive, both her and Ms. Parkhurst and her attorney would not, and still continue to this day, to not provide the information that I need to, 1, know exactly what's going on, and 2, make sure that my kids are safe. And that is the end all be all. End all be all. There were people in the house that I believe were not there voluntarily. They were told that she needed 2 weeks of support. There was just a variety of things going on that led me to have to spend money traveling to Atlanta, getting hotel rooms, trying to get a hold of my children, going back and forth between basically the Marietta area and LJ to try to handle all of this, while Ms. Parkhurst was sitting in a psychiatric ward under no authority to make decisions, but still was trying to control the scene the entire time. All the while, contacts were dismissive, not giving appropriate information. Melody was not giving appropriate information. Melody would not give me her ID. It was like working inside of a black box, but trying to do the best thing that I could for my children. At the end of the day, the children did not have a legal custodian during that time because Miss Parkhurst did not have decision-making authority, and she would not allow me the decision-making authority as well. That is the end-all be-all. I did all that I could as a parent to come and help my children, and that's it. That's all I did. I went beyond out of my way to do what was best for my children, and even to this day, Miss Parkhurst is trying to throw things against the wall as to why I still should be restricted. That is literally all I have to say. I'm at my wit's end. I've gotten no information from them, and frankly, I can't believe this was not an emergency situation in DeKalb County where there's 24 hours notice and we had a hearing right away. It's mind-boggling to me. That's all I literally have to present on this case.
Okay, so let me go through and tell you why I'm going to deny the petition. I do not deem this to be an emergency. Again, the legal standard is a material change of circumstances that have adversely impacted the children, Mr. Parkhurst. Let me just tell you the evidence that the court heard today that was introduced and entered. First, it is undisputed that Ms. Parkhurst was admitted to Peachford. What maybe remains in dispute is whether it was voluntary or involuntary, as Mr. Parkhurst has continued to raise as a concern that the court should be aware of. Notwithstanding that, there is a letter that has been entered without objection from the provider at Peachford, indicating that notwithstanding the admission of Ms. Parkhurst, she is released with a plan of care, which includes continuous support from her treatment provider, as well as the fact that she is released without restriction to return to work, court for these proceedings, as well as to parenting her children, your children. Notwithstanding what one might believe is behind that, notwithstanding Ms. Parkhurst's testimony that her diagnosis was that of anxiety and depression, and notwithstanding, Mr. Parkhurst, the fact that you may think there's some other diagnosis, notwithstanding that, she was released to care for the children. Excuse me, give me 1 second. I've got children coming in. Hold on. Okay, I apologize for the interruption. So what I was saying is, notwithstanding that, Ms. Parkhurst has been released by those treatment providers without restriction. And so for that reason, any concerns about her ability to parent, which is what she was granted in the court's last order, have been satisfied as far as the court is concerned, given that release document. Now, let me say this, Mr. Parkhurst. I absolutely think you did what you were supposed to do. When you got notice that there was an emergency with Ms. Parkhurst having to be admitted to a hospital facility, that is akin to some parent being in a car accident or having some other emergency. You absolutely did what you were supposed to do. However, what Ms. Parkhurst said is accurate, and I would assume that this will be accurate if the children were in your care. When you have an emergency, that in and of itself doesn't lend itself to a change of custody. It simply means that the court, when you involve the court, needs to look at whether that emergency is ongoing or whether something happened that is going to adversely impact the custodial parent's ability to parent. There's been no supportive evidence of that. You haven't met that burden here today. So simply saying, I didn't get information when it happened that is to your liking does not rise to the level of a concern for the court. What the court did here today is that two sisters were in contact with you at various points and you had their information as well. They weren't going to give you her diagnosis. They weren't going to give you all of the full details about what was going on. But they gave you information. They told you where the children were. They told you that the children were safe. You also had the opportunity, as you said, to speak to the children. What is noted today in this hearing is, I didn't hear anybody say that the children asked to go with you. They stayed with the caregivers.
Children did ask.
Hold on a second. Also, what I heard is that the friend that you all have in common that stepped in to help parent these children while Ms. Parkhurst had her medical emergency, made sure the children were safe and got to where they needed to be. So like she said, there was a safety net put in place, which is what one would expect for any family, whether they were in your care, Mr. Parkhurst, or in her care, Ms. Parkhurst. A safety net needs to be in place when an emergency arises. That's what happened here. That's the court's vantage point here. So where are we today? The emergency is over. You've had evidence, at least as of a week ago. It sounds like perhaps you were told the emergency was over, but notwithstanding whether or not you were told, at least as of a week ago, Ms. Safako sent you some exhibits, which included that letter.
That letter doesn't say anything.
She told you, but then in P2, there is a letter that says that Ms. Parkhurst was released with no restrictions. So though Ms. Safako told you,
say voluntary or involuntary.
It doesn't matter about whether her initial arrival to that hospital was voluntary or involuntary. It does not legally, because a medical provider released her to return to those activities, sir. So I'm sorry that you don't agree. I'm not sorry that you don't agree. You don't have to agree, but that is the law. I have to look at the evidence that I have here, and you saying something doesn't make it so. That's what I think the problem you're having here. You calling the hospital, demanding information about her. That was not the time to do that. You were supposed to be making sure the children were safe and secure. And you were given information to verify that.
You can't say that. I never did.
You repeatedly called the hospital. That is the evidence.
To try to get a hold of the person who was in the hospital.
Mr. Parkhurst, I'm not talking for a response right now. I'm telling you what the evidence has been during this hearing. And not only did you call the hospital, but you called the friend who was caring for the children, and she testified that her husband instructed her to stop taking your calls and to just provide you with transactional information in text messages. So that is a pattern of behavior that doesn't go to the best interests of the children necessarily. You were trying to find out what was going on with Ms. Parkhurst. And while that is information that is relevant concerning what she would be able to do in the moment of her emergency, and when that emergency concluded, you were given enough information, and you were most certainly given enough information when the letter came to you that is part of P2 that told you that that emergency was no longer ongoing. Now, I understand why you filed the motion initially. You did not necessarily articulate in the motion something that was emergent. And her response, as you know, because I brought it up earlier, was that the children were safe. They were safe. Here is who they were with. Their activities have continued. They're safe. And by the way, I am no longer in the hospital. I am under the care of a physician, and I've been released. That's why it was no longer an emergency. So that's just like a person who has to go to the hospital ER and they break their leg and they have to wear a neck collar. When that ends, the emergency part of it is over. And if they put a contingency plan in action, you may or may not be needed in that moment. Now, that has to be viewed with a different lens for you, Mr. Parkhurst, because if you're talking about adverse impact to the children, what she's introduced is a positive breathalyzer test.
There was no children around during the positive breathalyzer test. It does not matter. You're not analyzing the information.
Well, what I am analyzing is what is in their best interest, and being around someone who has yet to address their issues with alcoholism is a concern for the court that has been a continuous concern. So if I'm sitting here literally with the chart, I was sitting here writing down the information, the repeated phone calls, the blowing of the positive alcohol test, that is the reason why you all were here in the first place.
No, that's not.
Still not addressed.
That's not why we were here in the first place.
You weren't here in terms of the custody determination.
No, that's not. That's also not why we were here in the first place on that.
I don't know what to tell you about your inability to comprehend what I'm saying. I don't know if I can say it any more clearly in the next 30 seconds. But the reality, sir, is you have some challenges with alcohol. They have manifested themselves in my hearings in terms of your responses just to the court and to Ms. Parkhurst. You were supposed to address your issues of alcoholism. That is why you have supervised visits with the children. I don't have confidence that you, will do it, and you most certainly have not done it. And that is additionally what I'm talking about right now. In an emergency hearing, I'm not going to award custody to you. And you just blew a positive alcohol result. That's going to be highly relevant in a different
county. So
it wouldn't be, well, you can certainly do what you feel you need to do within the confines of the law. Yep. But with that, I'm going to deny the motion. And Ms. Safakos, please prepare an order regarding the same. You all are excused. Have a great day. Bye-bye.
Thank you, Your Honor.